Good morning. My name's Bob Bernhardt. I'm the Director of Education at the Law Society here. It's interesting to look out. I was here, I guess, last Friday saying goodbye to the first group for Phase 1. And I think you're younger than them by about, well, maybe not, but it's close in age anyway. So delighted to see you here today for the new Workplace Safety and Insurance Appeals Tribunal, the process, the appeals, the law. The materials you have are all complete. There are no additional handouts to be made. All of the sessions that are taking place will take place in this building. And I shall start off quickly because Dan tells me there's a full day. And so I'd like to introduce the chair of the program, Dan Revington. Dan is General Counsel of the Workplace Safety Insurance Appeals Tribunal. He's chair of the Workers' Compensation section of the Canadian Bar Association and a member of the Workplace Safety and Insurance Law Specialty Committee of the Law Society. Prior to joining the tribunal, Dan was manager of the Officer of the Employer Advisor, where he represented employers in many leading case appeals. Before that, he practiced civil litigation with a Toronto firm, where he specialized in personal injury work and represented numerous injured workers in compensation appeals. I hear you have a good program. I hope you enjoy it. Dan?
Well, thanks very much. On behalf of the Law Society of Upper Canada and the Canadian Bar Association, I'd like to welcome you all here today. I can also tell you on behalf of the Bar Association and the Law Society, we're very pleased that this program has attracted the attention that it has. You know, when you put together a program, you're never really sure if people are going to be interested enough to come to it. You're always sort of guessing. And when we first set it up, I was hoping that we'd attract at least 70. And then 3 weeks ago, they called and said, Dan, I think we're going to hit 70. And then about 2 weeks ago, they said, Dan, I think we're going to go over 70. And then, Dan, we're at 144. And Dan, we're at 177. And Dan, we're at 200. And we're running out of room for some of the sessions. So we had to close off registrations a week ago. And my apologies to those who've been calling the people at the Law Society and calling me directly at my office, hoping to get in, but I understand this is being videotaped, so at least some of the sessions will be available to people who weren't able to register in time, and we're going to have a look at how many registrations didn't get processed in time to see if there's it's going to be worthwhile to run another session. And congratulations to all of you who were quick off the mark in getting your registrations in. It's actually fitting that we have this program here at the Law Society. This is actually the first workers' compensation program that is a joint program of the Law Society and the Canadian Bar Association. And the reason it's fitting is that, as most of you know, some years ago they did away with the Queen's Counsel designation in Ontario, the QC designation. And instead they created these specialist certification programs so that lawyers who wanted to be known as a specialist in a certain area have to apply and be approved by a specialty committee. They can put on their letterhead that, and the Law Society will advertise that they've been designated as a specialist in a certain area of the law. And one of the areas of the law was workers' compensation law. When they set up a workers' compensation specialty committee, they put equal numbers of worker and employer reps on the specialty committee to set standards for the for people seeking specialization. And as most of you know, workers' compensation law is one of the most polarized areas of the law. People who practice in workers' compensation are passionately partisan. You're either on the side of the angels or you're not. So when we came together, we were curious as to how this program was going to work. And we were amazed that we all got along so well together. And we were very pleased that we were able to put together some very good standards for certification. We were amazed at the number of issues that we agreed on. And we decided that we wanted to be able to take this meeting of the minds on a surprising number of issues farther. A few years ago, there was a study done by Minister Cam Jackson into some various areas of the workers' compensation system, and we on the specialty committee wanted to make submissions, joint submissions, to Minister Jackson. And we asked the Law Society about that, and they said, no, that's not what specialty committees are supposed to do. So Those of us on the specialty committee just went down to the Canadian Bar Association, met with the people there, and we set up the Workers' Compensation Law Specialty Committee. And that Workers' Compensation Law section has proven to be more successful than any of us ever expected. Workers' Compensation is actually a fairly small bar, but last I counted, we had 150 members of our section. We're the only section that's increased membership year after year. We've put on a number of very interesting dinner programs. Most recently, the program we ran was Should Experience Rating Be Abolished? And we also did a program on the occupational health and safety tragedy in Sarnia. We put out a newsletter which has recent tribunal decisions, recent court decisions, book reviews, and reports on the educational programs that the section runs. In addition, we've been able to make submissions to various government bodies, joint submissions, incredibly enough for workers' compensation bar, to various government studies on 4 separate occasions. So the section has actually been extremely successful. And if this sounds like a plug for the CBAO section, you're right. That's exactly what it is. I know a number of you are already members. Some of you who are not may want to consider joining. We have our year-end meeting a week tomorrow. One of the things the section did was we created the Ron Ellis Award for Excellence in Workers' Compensation Law. And last year we presented it to Dr. Robert Elgie, who's a former Minister of Labor, neurosurgeon and a lawyer, and Gary Newhouse has also won the award. Gary is co-author of Workers' Compensation Ontario, Butterworth's Workers' Compensation Ontario, and Gary's been representing injured workers for years. This year's winner is Alec Farquhar, who is the director of the Office of the Worker Advisor. And there's some registration forms, I understand, that are out there with the registration people. So we'd certainly invite you to come. It's a fun evening, these awards, and it starts at 5:30 next Wednesday, June the 7th. So, the program itself. This is a really exciting program, and I'm pleased to say that the quality of the speakers we've been able to attract today for this area of law are just unsurpassed in terms of their expertise and their experience. We're going to start off the program with the chair of the tribunal, Ian Strachan, and the executive director, Zeynep Onen, and I'm going to introduce them in just a minute. But before I do that, I just want to give you an overview of what the program is going to be like today. And after Ian and Zeynep speak and Dave Gorelle speaks, then we have a coffee break. And at the end of the coffee break, you don't come back here, you go to your small group room. And if you look in your materials, I think it's a blue colored page, you'll see that every one of you has been assigned to a different small group, each led by a vice chair of the tribunal. So at the coffee break, everybody goes to their small groups, and there's a map included with your materials to tell you where your small group is, either the 2nd, 3rd, or 4th floor in the Law Society. And I think it's at the back of the materials are the questions that are going to be addressed in the small group. And the idea is to be a sort of a roundtable discussion led by the vice chair, and they encourage your questions and encourage discussion. At 12 o'clock, when the small group session ends, then we all go to the Colony Hotel for lunch, and we sit in the same small groups. So the room number that you're assigned to for your small group is also going to be on your table when you get to the Colony Hotel, so you'll be sitting in the same small group with the vice chair at the Colony Hotel. And after lunch, we come back here at 1:15, Ministers of Labor speaking at lunch. After lunch, we come back here at 1:15, and we have some of the substantive law sessions for the balance of the afternoon. So that's what we're going to do. If for any reason your name's not on a small group list, you can talk to the people at the registrations desk at the break, and we'll make sure we fit you into one of the groups. So for the first speaker, we have Ian Strachan. Ian is the chair of the Workplace Safety and Insurance Appeals Tribunal. Ian's been chair for almost exactly 3 years. He's been a vice chair at the tribunal since 1986. Prior to that, Ian practiced for 15 years with Osler Hoskin and subsequently with Lockwood, Belmore, and Strachan. Ian's frequently invited to speak on workplace safety and insurance issues. Anytime he's spoken at the CBAO Workers' Compensation section, he's always proven to be our biggest draw of the year. I don't know, Ian has only been chair for 3 years at the Tribunal, which in terms of the total time frame of the Tribunal is a relatively short period of time. The vast majority of the changes, the structural administrative change to the Tribunal, have occurred during Ian's tenure. And Ian's just about to tell you about them. I will say that the format we're going to follow is that after each speaker, he or she will invite questions from the audience, and depending on our time, he'll take the questions, and then when we run out of time, we'll just move on to the next speaker. So thanks. Ian?
Thank you, Dan. Good morning, and welcome to our program on the new Appeals Tribunal. I almost said the new and improved Appeals Tribunal, but I thought it might sound a little too much like I was pitching a commercial for a headache remedy, so I won't say that. My other omission, I guess, relates to visuals. As I was having my very short jog this morning, I realized that I had forgotten to respond to an email about whether or not I had visuals. And it occurred to me that what I should really have this morning for you is some kind of snappy visual showing a tired old man disappearing into a phone booth, and then this young, vibrant person emerging in Wissiat costume and cape, soaring off into the stratosphere. Very symbolic. I apologize for the omission. If you feel a need this early in the morning for that type of thing, try to visualize Dan Revington as Superman, soaring off to the Court of Appeal to do good work. The program is billed as the new Appeals Tribunal. However, you should know that it remains an appeals tribunal that is dedicated to the provision of quality adjudication, provided on a cost-effective basis. In dealing with appeals, the tribunal's basic goal or mission remains get it right. But a corollary is now do it faster. And that corollary is in part a response to a review by the Ombudsman and the tribunal's undertaking to reduce its active inventory by March 31, 2002. As most of you know, over the last few years, the tribunal experienced an increase in its appeal inflow of over 400%. The Ministry of Labor, of course, is concerned that we not ask for a corresponding increase in our budget to deal with that caseload. They need not worry. The tribunal is very conscious of the fact that every dollar added to its budget is a dollar that could otherwise flow to injured workers or employers in the province of Ontario. And it is for this reason that I say our goal is to provide you with a quality adjudicative process on a cost-effective basis. Some of you today will have heard parts of what I have to say. However, for the benefit of those who have not, and we do have some attendees here this morning from the Nova Scotia Appeals Tribunal, let me give you an outline of what I propose to cover this morning. Firstly, I'd like to give you a very brief overview of how the tribunal got to its current caseload situation. Secondly, I'd like to outline some of the restructuring changes and changes in process at the tribunal. Thirdly, I'll try to give you a general view of what the tribunal may look like once it has completed its undertaking to the Ombudsman by April 2002. And fourthly, I'll try and save some time for a few questions. As Dan mentioned, Zeynep Onen will be speaking to you in more detail about some of the processes, and in particular the Vice Chair Registrar operation. So it's probably more appropriate to hold your questions on that aspect of the operation for her and for Martha Kyle, the Vice Chair Registrar. I should also say that I'll be around for the entire day, so feel free to speak to me at any time with any questions or comments if you're more comfortable doing that. Some time ago, I spoke to the Canadian Bar Association about the Tribunal's increased caseload, and I made reference to the former Dean of the University of Toronto Law School, Caesar Wright. He was in his last year as Dean when I entered law school. I heard that, Martha. It was not 100 years ago that I entered law school. Caesar Wright had two favorite sayings when he spoke to new law students. The first was the comment to the effect that look to your left, look to your right. At the end of the year, one of you will be gone. That certainly got everyone's attention. He then went on to one of his favorite themes of the law as it is and the law as it should be. And he urged his students to constantly strive to improve the state of the law in Canada. When I spoke to the Bar Association, I spoke about the Tribunal as it is and the Tribunal as it should be. And I mentioned at that time that I would like to tell the audience that the Tribunal was an organization which had an annual inflow of appeals from 1,000 to 2,000 cases, where parties received a hearing within 90 days of being ready to proceed to hearing, and where they received a decision within 6 weeks after the hearing. That was the vision of the Tribunal as it should be. The speech was given about a year ago when the annual inflow figure was confirmed at around 11,000 cases. You don't want to hear about the Tribunal as it was at that point. Enough of you are aware of what it was like. The Tribunal was initially designed to be a low-volume final appeal level. It was designed to be driven by a Tribunal Counsel Office, with TCO preparing all of the case descriptions, appearing at most hearings to make submissions and provide advice to panels. It was a very labor-intensive process designed to deal with 800 to 1,200 appeals a year. And even at that volume, the Tribunal had difficulty coping from time to time. When the inflow reached about 1,500 cases around 1990, the Tribunal began to accumulate a bit of a backlog. The inflow continued to grow and reached about 2,300 cases in 1995. In 1996, it began to grow exponentially. It reached 3,600 cases in 1996, 5,000 in 97, and topped out in 98 at around 11,000. In 1999, it fell back to approximately 6,500. There are a number of reasons for the increase. Firstly, changes in legislation made over the years made the system more complicated and probably resulted in more appeals. Even though the number of claims filed at the board during the 1990s was declining. I think between 90 and 98, it went from about 475 down to about 345,000. Secondly, the board traditionally had 3 levels of filters for claims working its way through the system. Before they reached the appeals tribunal, you had the first filter at the claims adjudication level, the second filter at the decision review branch level, and then the third filter at the appeals branch. Well, when the board eliminated that second filter, the decision review branch, it meant that the board's final level of appeal, the appeals branch, received a dramatic increase in the number of appeals. And when you consider that 50% of final appeals branch decisions are appealed to the tribunal, that meant a significant increase for the tribunal. Thirdly, the board had accumulated a backlog and made a concerted effort to eliminate that backlog. That also increased the number of appeals going to the board's appeals branch, which in turn tracked through to the tribunal. And of course, Bill 99, with the introduction of limitation periods, meant that parties were more conscious of filing appeals to protect appeal rights against those limitation periods. So you had several factors combining to increase the flow into an organization that was essentially designed as a low-volume final appeal process. Now, over the last 3 years, the tribunal did increase its productivity significantly. It's increased the 1999 appeals dispositions to over 6,500, and that represents a 100% increase over 1997 production. 1997 had represented a 20% increase over 96. But while there was a significant increase in production, it wasn't sufficient to cope with that massive inflow. Hence the backlog, hence the need for restructuring, which puts the tribunal in a position to give its undertaking to the Ombudsman to reduce its active inventory. So how does an appeal body cope with a 400% increase without a 400% budget increase? Well, it starts with the board. We begin by looking at the entire adjudicative system within the workplace safety and insurance system. The appeals tribunal does not control the system, as you know. While it attempts to anticipate problems and set up mechanisms for dealing with those problems, it's a body which is essentially driven by the board process. And it's for this reason that we have attempted over the last few years to have much greater communication with the board to identify areas where we could improve the overall adjudicative system. To give you one example, the whole person adjudicative guideline, which hopefully many of you have seen, is a result of our increased communication. It's an attempt by the tribunal and the board to marry outstanding issues and claims so they are dealt with as one appeal and not on a piecemeal basis. While the principle seems obvious, the devil is in the details, not to mention the introduction of time limits, which means that some cases cannot remain at the board until the related issues are resolved. To deal with this problem, the tribunal created the inactive status category, whereby appellants can file a notice of appeal but request that the case be classified as inactive until the related issues are resolved at the board. And if those related issues are resolved to the satisfaction of the parties, it may mean that the appeal at the tribunal is withdrawn. Typical example is a claim for an organic-based disability which arrives at the tribunal. The non-organic element is still working its way through the board. If it's resolved at WSIB on a whole person basis, it may mean that the appeal at the tribunal would disappear. Second example, and an extremely important one from the tribunal's perspective, is a relatively new process which you should be aware of. It involves essentially a board certification process. The tribunal has historically and still is spending a great deal of time on such items as related claims and appeals, information on employer status, updating board files and medical records, and obtaining applicable board policy. This tribunal processing by the Tribunal Counsel Office and the Vice Chair Registrar teams is designed to ensure that the case record is essentially hearing ready when it is sent to the scheduling department for a hearing date. The board certification process is designed to shorten the timelines at the tribunal by instituting what is essentially a one-stop shopping process. The board certification process should result, once it's working a little more smoothly, in the parties and the tribunal receiving essentially a hearing-ready file from WSIB. The board will certify before they send the file to the tribunal that the employer status information is correct and current, that all related files have been examined or included, that the advice on the board policy is complete, and all new medical evidence is included. As the tribunal's active inventory reduces, this certification process should, by ensuring that the case record is hearing ready, result in shrinking timelines between a party's request for a hearing date and the actual hearing. As I mentioned earlier, this process is new, and people like Zeynep Onen at the tribunal and John Slinger and Brenda Abrams at the board deserve a great deal of credit for their ongoing work in attempting to make the certification process an effective tool in processing appeals within the system. Let me move from the board and the system to the tribunal. I spoke earlier about the original tribunal model, essentially an organization driven by the Tribunal Counsel Office, with abbreviated case descriptions, TCO attendance at hearings, submissions and advice to panels. The model didn't last very long, and TCO became more of a production center than a pure counsel office. It gradually took over the entire production process, from intake department through records department, case analysis, medical liaison office, production of case records, and occasionally attendance at hearings. The current tribunal structure excuse me, represents an attempt to return the Tribunal Counsel Office to its original role as a counsel office, concentrating on the most complex cases which require significant involvement by legal staff. The structure which has allowed TCO to return to its original role is the Office of the Vice Chair Registrar, or VCR. As I mentioned, Zeynep will be giving you a more detailed overview of this process. However, let me give you the bare bones so you can see how TCO dovetails with the VCR. Love these little letters and acronyms. Now that the tribunal has built a substantial body of case law, there's less need for a tribunal workup on every case. And this is particularly so if the concepts of whole person adjudication and board certification work effectively. As a result, appeals flowing into the tribunal can pass through the VCR, where they will be directed to one of 4 basic streams. Firstly, there's the written stream, which is a self-selected stream and at the moment primarily involves employer assessment appeals. Secondly, there is the TCO or complex case stream, which involves the most complicated cases, for example, industrial disease cases, employer classification cases, and novel legal or medical issues. TCO also includes the Medical Liaison Office, MLO, which is the tribunal's contact or liaison with the tribunal's roster of medical counselors. And I'd just like to say a brief word about the role of the counselors. As some of you know, the tribunal has the benefit of the expertise of a small number of medical specialists who review files for medical completeness and direct the attention of MLO or TCO to potential problems in the file from a medical perspective. At the moment, the medical counselor group is chaired by Dr. Ross Fleming, a respected neurosurgeon associated with the University of Toronto. And when I speak about our attempts to provide quality adjudicative service to the injured worker and employer communities, I usually attempt to give the medical counselors considerable credit for the manner in which the tribunal addresses medical issues. They also provide a valuable service in our training programs by delivering lectures or papers from time to time. I'm sure many of you are aware of the collection of generic medical papers which can be found in our library and which are extremely helpful to representatives preparing cases. The counselor's expertise is also useful for new adjudicators and is an important part of our overall quality control process. Thirdly, the VCR may direct a case to the ADR mediation stream. This is essentially a self-selecting stream where the parties feel that a mediated settlement is realistic. And in the basic ADR process, alternative dispute resolution, the parties meet with a resolution officer to discuss the appeal, and in the event the issue can be resolved, the officer prepares a recommendation which is taken to a vice chair. If the vice chair agrees with the recommendation and is satisfied that it complies with the legislation and board policy, then the vice chair will write up the recommendation in the form of a brief decision. Now, a recent variation on this process involves mediation by a 2-person team made up of 1 worker member and 1 employer member. They conduct the mediation as a joint operation, and where they are satisfied with the result, they prepare the recommendation for the vice chair, who in turn reviews it and may approve it in the form of a brief decision. So far, this process has been getting reasonably good reviews because the parties appear to like the informality and non-adversarial atmosphere. And for those of you who have been through the process, I would be very interested in any comments you may have about the way the process works and any suggestions for improving it. The 4th stream is the normal hearing stream. And in this stream, appeals are assigned to a panel or vice chair as a single adjudicator, and usually involve a half-day or full-day hearing. We are still attempting to arrange some batch hearings, batched on the basis of the same party or parties or same representatives. However, because the tribunal's caseload comes from such diverse sources, this tool will probably have limited usefulness in dealing with the enormous caseload. I know some of you are interested in the changes to the adjudicator roster, and I'll just say a word about that. The tribunal has substantially increased its rosters of adjudicators, particularly vice chairs. Those of you who have appeared regularly over the past year will have noticed a number of new faces. They've been added to the roster in small groups over the past 18 months. And the tribunal has basically doubled its complement of vice chairs from 29 at the beginning of 1999 to the current 55. Adding those adjudicators in small segments has allowed the tribunal to gradually integrate the individuals into the adjudicative system. And as they become more experienced and more productive, they should have a dramatic impact on the tribunal's caseload, and this should become apparent towards the end of this year. The larger roster will also give the tribunal greater flexibility in managing vice chair caseloads, and hopefully this should lead to faster release of decisions. In addition to the significant additions to the adjudicative roster, there have been some key changes in senior management. To mention a few, Zeynep Onen has become the executive director, Dan Revington is the new general counsel, Martha Kyle has assumed the mantle of the vice chair registrar, and Robert Glass has filled the position of Director of Finance and Administration. Now, let me touch briefly on the issue of quality in the process. When I spoke at a series of outreach programs around the province last fall, the one consistent theme which I encountered was a combination of appreciation for the tribunal's efforts in attempting to increase productivity, but with a related concern about the possibility of achieving increased production at the cost of a substantial erosion in the quality of the product. When considering this potential tug of war between quantity and quality, I was often asked whether there are any mechanisms in place at the tribunal to ensure delivery of a quality product. And at the risk of boring some of you who are very familiar with these mechanisms, let me touch upon a couple. Start with the new adjudicators who arrive at the tribunal. They go through a reasonably intensive internal training program run by Carol Prest and the Office of Counsel to the Chair, OCC. In addition, they attend a one-week external program for adjudicators run by SOAR, the Society of Adjudicators and Regulators. They're required to observe at least 10 hearings and write draft decisions based upon some of the hearings which they have observed. Those draft decisions are critiqued by Carol Prest and her team, and once they are satisfied with the quality of the drafts, the adjudicator or vice chair is scheduled as part of a panel with 2 other experienced adjudicators. Other quality checks in the tribunal process are the TCO MLO office with respect to medical and legal issues. In addition, OCC provides ongoing research assistance and a review process for draft decisions prepared by vice chairs. And last but not least, there's the informal peer review process at the tribunal. Since OICs read the decision summaries and other vice chair decisions, they select and discuss decisions at assembly meetings, training programs, and what we call informal brown bag sessions, lunch sessions, sort of the consolidated Bathurst concept. In addition, we are attempting to develop what we're calling a quality loop process, whereby the tribunal and the board can identify potential problem areas within the entire adjudicative system. This does not involve the Section 126 process. It's rather an attempt to identify areas which could benefit from some discussion and review. And the whole person adjudication guideline and the file certification process are two items which have resulted from this quality loop operation. Again, I'll touch briefly on one item that used to be a sore point, but I don't think it is anymore, and that's the Code of Conduct for Representatives. We were losing a number of hearings to adjournments because some representatives were not prepared. In an attempt to address that issue, we developed a Code of Conduct for Representatives and backed it up with a practice direction. It seemed to be a timely exercise because as we released the Code of Conduct, the Attorney General commissioned a study by Justice Peter Corey on paralegals in the province, and the Law Society also commissioned a review of the role of paralegals. Both those studies were extremely interested in our Code of Conduct, and I don't know whether we'll get applause for it, but there certainly is a great deal of interest. It's too early to tell how effective it will be, but we're hoping. Lastly, and because I'm sure someone will ask me about this in any event, a brief update on the Section 126 process. And just to refresh your memories, this is the process whereby the tribunal applies board policy under Section 126. If the tribunal concludes that the board policy is inconsistent with the Act or does not apply to the case, then the tribunal refers the board policy back to the board along with the tribunal's reasons for reaching its conclusion. The board reviews its policy and issues a direction under subsection 8. Now, although the tribunal only had about 50 stress cases in a 1999 active inventory of over 9,000, this handful of cases attracted an unusual degree of attention, primarily because of the Section 126 issue. Decisions 262-99I2 and 809-98I2 were stress cases where the panels referred the policy issue back to WISIB's corporate board of directors. And as some of you are aware, the corporate board reviewed the history of WISIB treatment of stress cases and concluded that the board practice in stress cases over the years did not constitute a policy for purposes of Section 126. If you read Decision 809-98, it contains a reasonably detailed analysis of policy and practice considerations. Now, in his letter to me advising of the corporate board's position, Glenn Wright also advised that WISIB is currently developing a policy on what constitutes policy for purposes of a Section 126 review. And when it's complete, hopefully it will help us avoid debates similar to the policy versus practice debate which arose in those stress cases. Now, not too bad. I do want to save some time for questions. So, in conclusion, I've tried to provide you with a snapshot of the tribunal as it is. An evolving tribunal with a massive caseload, which is being reduced to date in accordance with the tribunal's projections. Once all of the tribunal's adjudicators become more experienced, I believe that you will see a dramatic difference in the tribunal caseload and timelines next year. However, the long-term issue of the tribunal, as it should be, is in part up to you. The Minister and the Ministry of Labor are always interested in your comments on how the entire adjudicative process within the workplace safety and insurance system should operate. My version of a top-quality, last-level review body with short timelines, clear, concise, and cogent decisions is still some distance in the future, but hopefully is getting closer. And with your help, the help of Glenn Wright and WISIB and the Ministry of Labor, I believe that the next 2 years will move us some distance towards that goal. Thank you very much. Now, there must be a couple of questions out there. No? All crystal clear? Yes?
The mediation process, like, do both the employer and the worker have to participate?
That was the original model, that both the employer and the worker did participate. We're now reviewing, we now have cases where there is only one party. And the check on that is the vice chair, who has to be satisfied that the result complies with the legislation and the board policy before he or she will incorporate it into a decision. Yes? Basically, it's up to the party to decide which witness is important and which testimony is relevant. What we do require is that you provide notice to the tribunal and the other party on the names of the witnesses and provide a will say statement, which is a summary of what the witness would say. Yes? Well, in theory, it could. I suppose if you called someone who had absolutely no knowledge of the case or was going to give testimony on an issue that was irrelevant to the issues under appeal, the Tribunal Counsel Office or VCR may try to persuade you that that person was unnecessary. It would also be open for the vice chair or panel to say that they didn't wish to hear from that witness because it wasn't relevant testimony. But I'm not aware of cases where, as a matter of course, we say to people, no, you can't have a witness. Yeah?
The review that's underway of the policy versus practice, I'm sorry I missed exactly who's doing that review. Can you also tell me if there will be other parties that will have input, and do you anticipate that there will be something definitive as a result?
That reference arose in the letter which I received from Glenn Wright on behalf of the Corporate Board of Directors. So it's WISIB that is preparing the policy on what constitutes policy for purposes of Section 126. So I'd suggest that you direct any inquiries to the board. I've heard nothing further on that, so I don't know what the status is.
Still on the mediation process, if the desired settlement is not satisfactory to the worker, do we then have the option of going on to a formal tribunal hearing?
Yes, you do. That, in fact, that is what happens. If it can't, if the mediation is unsuccessful, then the case moves on to a hearing.
Has the tribunal come up with a paper regarding taking jurisdiction for decisions on not extending the time limit and also finding it inadvisable to consider decisions that were operational versus appeals?
No, that issue is at the tribunal at the moment. I'm not aware of decisions that have been released on that yet. Zeynep may have some more current information on that.
I don't know if this is on, but as I understand it, those are cases to be heard yet, and I think there is going to be submission from tribunal counsel on that, so that would be available to everybody.
What legal recourse would the tribunal have? If, for example, the board would write a policy, and in your view, that policy would tie your hand to a policy of the board, but the law, which is the act, would be violated through that policy.
Are you thinking of a constitutional argument or issue?
Yes.
It's probably an issue that would be determined by the divisional court and onto the Court of Appeal. I suspect because it's such a controversial issue, and it has been raised peripherally in a couple of appeals, but I don't believe it's been argued fully. Dan Revington may have some more current information on that. But it's the type of issue that ultimately would wind up in the divisional court, in my view.
would the tribunal argue that case, that situation?
We appear at divisional court and at the Court of Appeal primarily in the role of an amicus curiae or friend of the court, to make sure that the court understands the role of the tribunal decisions, and the reason for the tribunal. So it's probably a question that you could direct to Mr. Revington, since he's undefeated in the divisional court so far. I told you he was Superman. Yes.
In your discussion and liaison process with the board, has there been any discussion or concern about timely implementation of tribunal decisions by the board? And would the tribunal contemplate making riders or stipulations in its decisions that the board implement whatever decision it is, worker, employer, or otherwise, within a reasonable period of time?
Do you want to speak to that? It's a subject that comes up from time to time, and a collateral issue is to what extent do new adjudicators at the board receive training or instruction on tribunal case law? Zeynep is involved in that group, and she may be able to answer that question better than me.
There is a group that meets regularly consisting of tribunal and board on interface issues, and right now it's called quality loop for historic reasons, not functional reasons. And that issue has come up. One of the things the board pointed out to us is that we need to close the file faster. There's a sort of an administrative matter of the board file. Unless it's closed at the tribunal level, the board will not implement the decision of the tribunal. So we're trying very hard to be up to date on file closures, and one of the reasons you may be experiencing delay is that we're not closing the file fast enough. We would be interested in knowing if there are other reasons. You can always call us to find out if the file's closed yet, and if there's further delay after that, then you should let us know, and we can explore that with the board and see what's possible.
We do it in communities outside Toronto. The co-mediators travel around the province with the vice chair. We haven't considered doing it by telephone conference yet. When I mentioned the project at a couple of outreach programs, there seemed to be some concern about the tribunal attempting to do it by telephone conference. For whatever reason, the parties didn't like the idea. But it is something that we could try in future if parties were interested in doing that.
How do you decide whether to have a single panel member or
There is a memo which the scheduling department has from me and sets out, I think there's about 6 basic areas. Things like cases involving a novel medical or legal issue, cases which turn almost entirely on credibility. Obviously, there's some credibility aspect in every single appeal, but where the case turns virtually entirely on credibility, that would normally attract a full panel. Cases which have significant financial implications for the insurance fund would normally attract a full panel. There are a couple of others, but those are the main ones. If you're interested, I could send you a copy of the memo. I think it is in public circulation. And in fact, I may have a copy in my briefcase I could give you during one of the breaks. We talked about having OEA have some involvement in some cases where there wasn't an employer representative. Generally, we have a fairly experienced roster where the adjudicators are aware of the employer's issues and concerns. So it's not as great a concern as it once was. But obviously, we would like to see more employer participation. My impression is that it has picked up, and there's greater interest on the part of employers. Even where the near window has closed, we will see employers appearing at the hearing. So yes, we're concerned about it, but it seems to be an issue that isn't causing serious problems at the tribunal at the moment.
In regards to the acceptance of information by the tribunal, in regards particularly to industrial disease matters, there are a number of peer-reviewed papers out there. Some of them were produced independently of the compensation board. Some were done through the Ministry of Labor, through the Occupational Disease Panel, the Occupational Disease Standards Panel, all of which, again, as I say, are peer-reviewed. And the tribunal, having that arm's length situation from the actual compensation system, actual WSIB system, would it not be to the advantage of the tribunal to accept those peer-reviewed papers in regard to the adjudication of industrial disease claims, even though the board itself has not accepted them in their entirety?
I'm a great fan of the common law because the law continually evolves on a case-by-case basis, and I think the distilled product you get at the end of the process is superior to what you get in something like a leading case strategy. So in answer to your question, I would say that that type of decision will be made by panels as they hear industrial disease cases, and the tribunal will gradually build up a body of case law which will hopefully address the issue that you've raised. In terms of an executive decision to recognize certain papers, the answer is no.
As a follow-up, I've had experience where those papers were not recognized by the tribunal simply because they were not recognized by the board. And again, I wonder about that arm's length with the process.
Well, it's also arm's length between the chair and the panel. And the panel has total jurisdiction to make a decision on what will be admitted and the weight that will be given to any type of evidence, including peer review papers. So I think I was speaking to the representatives from the Nova Scotia Appeals Tribunal yesterday, and they have just gone through a major occupational disease case down there. And they have, I think it was 250 occupational disease cases left in their backlog of 450 cases. So they will be building up a substantial body of case law on that type of evidence. And I think with the occupational disease cases tracking through the Ontario system, in due course, the Appeals Tribunal will have the same type of body of case law, and that will address your concerns. I think I'm being cut off here, but you may have some questions after Zeynep's talk. Thank you.
Thanks, Ian. As Ian said, he'll be around for the balance of the day, and he'll be leading one of the small group sessions if you want to corner him and ask him some more questions. Next on the agenda is Zeynep Onen. Martha Kyle was originally scheduled to do this presentation, but over the last few months, Zeynep's actually assumed responsibility for overseeing case processing at the tribunal. Fans of Martha will be relieved to know she's still leading one of the small groups, so you'll still have a chance to talk to her. Zeynep's the vice chair and executive director of the tribunal. She was called to the bar in '82. She was senior counsel at the tribunal until 1988, became a vice chair in 1988, and she has a reputation for handling many of the most complex appeals that have been dealt with at the tribunal. In addition to hearing appeals and her general administrative duties, her current responsibility includes managing the processing of appeals at the tribunal, with particular emphasis on the project to reduce its inventory. Zeynep.
Before you think that I'm superhuman too, I should let you know that we're currently in the process of recruiting an assistant registrar at the tribunal. must say that the title of this conference, the new WSIAT, was somewhat daunting when I started to think about what I should say today, especially following Ian, who I knew would be very thorough and entertaining and informative. As Ian noted, there had to be a very significant increase in the number of appeals processed, started, and finished at the tribunal on very short order, and that translated to significant internal changes at the appeals tribunal. On the other hand, there are many aspects of the tribunal's work which we have tried to maintain as a constant, knowing that the baby is worth keeping, even if the bathwater in whole or in part must be jettisoned. The keepers included, and I think I'm echoing Ian here, commitment to quality in the hearing process and in the decision-making process, the need to try and ensure completeness prior to hearing, the use of tribunal's resources where necessary to investigate. The changes that I'll be discussing this morning started in the summer of 1999. We started to experiment with different approaches to case process prior to hearing. And you should remember that I'm basically going to talk only about cases, process for cases up to scheduling. In making all these changes and speaking with representatives and parties, we tried very hard to make sure that the process remained as constant as possible from their point of view. Continuity is important, even if internally we're trying different approaches to make sure that the cases get through in a timely manner. There were 5 principles that guided us in looking at how we would have to change things. First of all, we continued to be, and we do continue to be, committed to excellence in adjudication. Secondly, we tried to focus our staff resources, which were fewer considering the larger number of cases that had to be processed, so that even though they could only open the file, they had to open the file fewer times than in the past when we had maybe 1,500 appeals, that they could do very significant work with the file when it was open. Third, we started to require the parties to do more of the case preparation prior to hearing. The tribunal has a history of investigating prior to hearing, and that had to be reduced because of resource issues and the timeliness issues. And we have been asking parties to obtain medical and other evidence, which was clearly necessary before the hearing could proceed. I'll talk about how that impacts when I talk about the mainstream. Fourth, we based our changes on the understanding that the board file would be certified and that we would get a complete document, one-stop shopping, one delivery, including policy statement, employer information, and so on. As Ian stated, we've spent significant amounts of staff time collecting bits and pieces of paper from the board over time on any given file to complete it enough that it could actually be heard. There are a number of you I see here who were with the tribunal previously, and I'm sure you know what I'm talking about. The fifth is flexibility, that there is merit in flexibility to try different approaches to process cases prior to hearing. If the outcome or the result merits it, we should try it. Based on these principles, what are the changes that we've introduced? I'll discuss the hearing process, the pre-hearing process from the intake into the scheduling format. I should preface my description of the process, though, by stating that the tribunal is currently struggling with a tremendous caseload. It's been asked to absorb a production load which is double its capacity from last year, and given the axiom that justice delayed is justice denied, it's appropriate to stick to the aggressive timetable. On the other hand, these demands also mean that the institution is creaking and groaning with the effort, and there will be times when we could do better. We count on you to point out to us those areas in which we can do better, whether it's in a particular case or systematically. On the other hand, I must also ask you for your forbearance, given that the tribunal has a rather monumental task ahead of it, and for your understanding, particularly for our staff, who on the other end of the phone may at times sound harried or harassed, and it's not due to you, it's simply due to the pressure of work. I have to say that one of the reasons I believe that the tribunal will cope with this increase in production, will deliver quality work, is our staff. We have an incredible staff which is trained, dedicated, and committed to the goal, and I'm very proud to be associated with them, I have to tell you. The initial processing stage. This happens in the intake department. The intake department really hasn't changed much from 5, 6, 7, 8 years ago. The appellant must complete the appeal application. I'm told by Dan that it's in tab 6 of your materials. Most of you, I'm sure, have seen this document. The application has to be complete before we will accept it. I know that this creates a lot of back and forth at the intake level between clerks working in the department and parties as they try and complete the document. Once it's complete, the respondent is given notice of the appeal, and the appeal is placed at the back of the intake appeal inventory, which currently numbers, I hate to tell you, 3,000 cases. Now, you may receive a call from intake staff at the very early stages of the appeal for any number of reasons, including questions about jurisdiction that are apparent on the face of the appeal application, the issue agenda, and similar problems. You should know that about 20% of appeals are withdrawn or closed at this stage in the appeal because people are simply in the wrong place for the remedy that they're looking for. We expect to make changes in the appeal application based on 2 recent developments. Ian spoke about one of them, the certification of the board file, and the expectation that we will very shortly start to receive the board file in one complete document. The second development is the 6-month limitation period for making appeals to the tribunal. We do expect that this will result in fresher appeals. As a result, this means that we will be able to change the AA, the appeal application, so that the parties will have greater control over how the appeal is filed and how it's processed. We'll be introducing these changes as a discussion, in a discussion format over the summer, probably later rather than sooner. After a case is completed, after a case has completed its waiting period and intake, and we can actually take it into the scheduling format, it is streamed. You've heard the word before, I'm sure. It basically applies to a process whereby the intake manager considers a case to see whether it should go into one of 5 processing streams, which would either take it to scheduling or a mediation result. The streams are the main stream, where the bulk of the files are processed, the written stream, ADR, Tribunal Counsel Office, and early intervention or batch hearings. I know that Ian touched on all of these, and I don't know how much more detail I can give you this morning, but I will try. The mainstream is, as I said, the focus of the majority of case processing. It functions to review the appeal, the board file, and the appeal application, and then anything else filed by the parties to consider whether the case is ready for scheduling. If the case is ready for scheduling, you will receive a letter, your case record, and the letter will say your case is proceeding into the scheduling department. It may point out something that the legal worker who reviewed the case noticed about your case that may indicate a problem, but we obviously didn't feel that it was important enough to withhold it from scheduling. When you get those letters, please pay attention to them. It means that your case will be scheduled in very short order. And if you're given a date, and then you say, well, there is this other issue at the board I'd like to join, I do have this other medical report I'd like to get, I have all these other witnesses, you will likely lose your date, and you may have to wait quite some time before you get another date. And I think you'll also get a lecture from somebody, probably in the scheduling department, about the enormous waste of resources that results in at a very difficult time for the tribunal. So I urge you to please read the letter that comes with your CR. Now, the other letter that you might get is that the staff have discovered difficulties with the case. It may be that there is a very relevant issue that is at a lower level at the board. It may be that there is insufficient evidence, medical evidence, for a period gap in the medical evidence. It may be that there's an inconsistency between the requested remedy and the jurisdiction. For whatever reason, the letter identifies the problem and asks you to address it. And again, that ball is in your court. And until you address it and deal with it, the case may well remain in inactive status. Once you deal with it, it will be placed back in active status, and it will be placed back in line where it was. I have to say that the question of missing medical evidence is a very significant one. As our staff looks through files to see that they can, to make a determination as to whether they can actually proceed to scheduling and that they will survive a hearing, the lack of medical evidence is palpable. Please file your appeals with the medical evidence whenever you can. If you have filed an appeal because you're faced with a 6-month deadline and you know you need additional evidence or that there's other evidence out there that needs to be obtained, tell us. Tell us. We will put the case on hold. It will be reactivated when you're ready to proceed at the stage at which it was placed on hold, so that you will not lose time from that perspective. So it is very important that you tell us what you intend to do with your case. If you don't intend to proceed right away, we need to know that. The written stream, Ian talked about this stream. We have a lot of applications for a written hearing which we in fact do not accept. The reason is that a lot of people think that we can hear chronic pain disability, initial entitlement cases, credibility cases and so on in written form, and we don't agree with that. In any case in which we think a panel needs to hear oral evidence, we will tell the parties that they have to go through an oral hearing. These cases, the cases that are suitable for this stream, in our view at this point, are very straightforward entitlement cases. For example, a NEL reassessment, or employer retroactive class experience rating amendment applications, and so on. If a case is suitable, I'm sure most of you know the process. The tribunal will ask for submissions. Once the submissions are received, the CR and the submissions are placed before either a vice chair or a panel, and you'll receive a decision in due course. Number 3 is alternative dispute resolution. Ian touched on this as well. The tribunal has had a mediation process in place for quite a few years now. It's a staff-based model, and that's continuing. It's what used to be called ER, early resolution. And in fact, it's been expanded. We now have 5 staff, including, I believe, about to join us is a bilingual mediator, so who can work in French as well. Pardon me. Now, many of you must be aware of the ADR format with staff. The staff has a meeting, a session with the parties. We try to confine staff mediation to cases in which both sides are participating, so there's a balance. And where there is a resolution, this is written up and signed off by the parties and the staff member, and the resolution, which looks very much like a decision. If you haven't seen it, it's actually appended to the decisions, is presented to the vice chair in written form with the case record, much like a written hearing. And the vice chair reviews the matter and makes a decision one way or the other to either confirm the recommendation or decide that they can't accept, in which case it may go to hearing, or it takes different paths depending on what the case requires at that point. The second format is co-mediation. This is new. Ian described this as well. It's a worker and employer member working as a team to mediate a case. We like this model because it met 2 problems. One is that we felt constrained in mediating cases in which only one party was participating. And by having a co-mediation model, we provide that dual viewpoint. The employer and the worker interests are in there within the mediation as represented by the co-mediators, and the party is the third individual or the third portion of that formula. The difference with this model is that the vice chair stands by as the mediation continues. The vice chair usually has another hearing assignment. If there is a settlement coming out of the mediation session, then the parties and the mediators meet with the vice chair. The vice chair is already prepared by reading the case materials ahead of time, and the vice chair will either decide to endorse the settlement and write a brief decision, or if the vice chair doesn't agree, then the matter, again, either goes into inactive status so the parties can think about it, or it may proceed to a full hearing. Tribunal Counsel Office is the fourth stream. It's for complex cases, medically complex, legally complex. For example, the Tribunal has really dealt with very few Bill 99 issues, and as those come to the fore, we will likely refer a number of them to the Tribunal Counsel Office in order to assist the panel with any interpretation issues that may arise. The process here hasn't really changed. You'll still be dealing with a legal worker or a counsel assigned to the case. And if you need to know more about it, I'm sure Dan would oblige. The Vice Chair Registrar is Martha Kyle, and she is a key part of the registrar concept for the tribunal, because the Vice Chair Registrar is effectively the gatekeeper for this whole system. She is available to provide rulings at the instance of the staff or the parties on preliminary matters. This gives both the parties and the staff a great deal more flexibility to deal with issues before having to go through the whole cumbersome mechanism of having it scheduled, having it put before a panel just to have the case go in a different direction, because it really wasn't ready for hearing at the tribunal after all. The Vice Chair Registrar makes decisions in written form, by telephone, orally, in person. And although there aren't that many decisions that come out of this, and the decisions are always in writing, by the way, as required, the fact that the Vice Chair Registrar can have discussions with parties about issues that were that could not be settled in discussions with staff previously gives the parties some comfort and a perspective on their case that they would not have otherwise had. And this has been a very useful role, and we're very grateful to Martha for putting enormous amounts of energy into it. Batch hearings and early intervention are not necessarily a stream, but a process that I would like to talk about because they are new. We do have legal workers in the registrar's office who are looking for opportunities to discuss their cases with representatives. And where a representative has a very large number of cases with the tribunal, and we can find this out by simply looking at our case tracking information, they may be invited to talk to us at a meeting about the cases. And if they are suitable, if they're fairly straightforward cases, they may in fact be able to be scheduled in what we call a batch format. That would mean up to 4. At this point, we think we can handle 4 in a day with the same vice chair. The requirement is that the parties all show up in the morning at the same time, so that the vice chair and the representative, or the panel and the representative, can actually case manage the cases, so that I don't quite know how they would resolve it, but for example, they may want to hear the very straightforward case first and leave the more difficult cases later, and so on. This is something we're just starting. As Ian said, we've had one session, and we have I believe 3 sessions scheduled early in June, so we'll report back on how we think that's working. The meetings with the representatives on a batch basis have been very positively received. And if you believe you have a number of cases that you'd like to discuss with someone at the tribunal, let me know, let the legal workers in the registrar's office know, and they will put you in touch with the right person. I'm nearly finished, but I can't end without talking about the Registrar Information Center, or RIC. That could be good news or bad news depending on what your last experience was. They're very dedicated people, but they do have a lot of work to do. And they are basically the people who are in charge of the file for an extensive period in its life. As you know, we have active and inactive a caseload of about 14,000 files. And we cannot assign them individually to people anymore. And that means they will spend a significant part of their lives at the tribunal in RIC, not assigned, but the staff of the Registrar Information Center are available to give you information on the status. They process routine correspondence and so on. So do call them if you require any information. I can give you their phone number later. Now, in conclusion, as always, if you have questions, please contact us. We do try to give out as much information as possible. If you, as I said to you before, if you sense that our staff is somewhat stressed at the other end of the line, I think the reasons are obvious. We're always very happy to receive your feedback, and we count on the community of employers, workers, and representatives to give us good information to allow us to improve the process. I thank you for your interest and attention this morning, and I'd be happy to answer any questions you may have. Yes. No, but I know the issue does come up, and it's not always, the answer is not always no in terms of what we say. We do ask that people let us know if they're on a list, and if there's a chance that the matter may adjourn at the tribunal, and we do recognize that the courts prevail in that respect. Our problem, as you know, is that it's we've tried to overbook, which is what a lot of agencies do in order to deal with that kind of problem. And in our context, it just doesn't work very well because our adjournments are not as predictable. And so where many tribunals may schedule, for example, 4, knowing that 1 will go ahead, and they can sort of reassign cases at the last minute so that they can spread things out among adjudicators. We have a very difficult time doing that. Our adjudicators spend usually on average 3 hours preparing for a hearing, so it's very hard to pull someone in at the last minute to take over without causing problems. So it's not as flexible as it looks, and so if there's some rigidity on the other end when you call up about this, that's the reason. The other thing that we have said to the parties is that we do expect, where possible, that you would get a replacement, that you would have someone standing in for you, especially if you're from a larger firm and so on. But we do sometimes obviously allow adjournments if you've said that it's impossible and that you're, for example, that you're the representative who's been with this case ever since the beginning. It's really important that you be there, you've prepared for it. That would be considered. I'll take it back with me and see what they say. I'm told I'm allowed one other question, so go ahead. I'm not aware of cases where we would do that. Obviously, if the respondent is holding the matter up, we would try and deal with it through the vice chair registrar or other problem-solving mechanisms that we have. But the idea here is that the appellant has to put their case forward first, and that's usually what we're looking at. So that would likely not happen. If it happens, I want to know. Okay, thank you very much.
Next on our program is Dave Gorelle. And before I introduce Dave, I'm going to just make a few comments about the small group workshops that we're going to move to immediately after the break. Now, for the benefit of those who came in a bit late, if you check your materials, the blue pages, you'll see that you've been assigned to a particular small group in the tribunal. And that each tribunal, we have 13 tribunal vice chairs here. Each one is going to lead one of these small groups. Now, I don't have time, unfortunately, to mention the qualifications of all the 13 tribunal vice chairs. Their bios are in the materials at tab 8. We're very appreciative that they've agreed to volunteer to come here to lead these small groups. In fact, I think this is from talking with people, I think this is the session that interests people the most. At least I want to do is mention their names. So we've got Jean-Guy Bigras, Brian Cook. Sorry, Brian, I noticed they spelled your name wrong in the materials. There's no E on the end of Cook. Marcia Faubert, Linda Gerke, Martha Kyle, Maureen Kenny, Nick McCombie, John Moore, Elaine Newman, Virginia Robeson, Janice Sandomierski. Janice, sorry, I see they said you were Jane Sandomierski. Janice Sandomierski, and of course Ian and Zeynep. It's quite a lineup. All of these people have years of experience being a vice chair at the tribunal. In fact, I did a tally using the tribunal's computer software, and these 13 people collectively have issued over 10,000 written decisions. So you're not going to find a more expert group of people on tribunal decisions anywhere. Each of you will go to the room indicated for your small group, which are on the second, third, or fourth floors. And you do that, go and grab your coffee and a muffin, then head on up there. It starts at 10:40. When the small group session ends at 12, then everybody goes to the Colony Hotel for lunch. And you're going to be sitting at tables as close as they can make them to the small group that you're going to at 1040, and the tables will have the room numbers at the Colony Hotel. So, for example, Marcia Faubert's group are meeting room 209A, and at lunch you're all going to sit at the table marked 209A. Now, to get to the Colony Hotel, go out those doors, go out the doors that lead to the City Hall Square, and then you go left, which is north, and you just go right past City Hall to the Colony Hotel. It's maybe not even probably 300 yards from the door of the Law Society. It's on the second floor. I think they call it the ballroom. And the Minister of Labour is scheduled to start his talk at the Colony at 12:15. So now I'm going to introduce our last speaker before the break, which is Dave Gorelle. Dave's a partner with Matthews Dinsdale, which is one of the leading management side firms in Toronto, and Dave is the firm's acknowledged authority on workplace safety and insurance law. Dave's appeared on dozens and dozens of appeals at the Tribunal and at the board. He's a past member of the Workers' Compensation Section Executive. He, in fact, is the first person who was ever to be certified as a specialist by the Law Society for Workers' Compensation Law. And, in fact, he's now chair of the Workers' Compensation Law Specialty Committee. Dave.
Thanks a lot, Dan. Thanks for the nice introduction, and it's nice to see everybody here today. I'm here to do my annual pitch for the specialist certification program that the Law Society has, and I would just like to see a show of hands. How many of you out there are aware of this program? Quite a few of you. Okay, so now the big question. Why do we only have 5 or 6 certified specialists in this area? Why are we not getting applicants? I'd like to issue a challenge to everybody today that before you, well, why don't we have the challenge right over the break that's coming up? If you could sit back and think of just one reason that's holding you back from applying to be certified as a specialist, I'd like to be able to review them. I come up and make this pitch every year, and every year I think we get one response in, and it really hasn't gotten too far. So I'd like to issue that challenge. We've been around since 1993, and we've had a great committee of very dedicated people. We've put together some decent materials, and I understand they're available for you here today. There's an information package somewhere, I'm assuming outside. And in it, I think, is contained the resource materials, the standards, the application forms, which I hope everyone will take a moment and fill out, and a directory of the current certified specialists. And as I say, that's not exactly a phone book, so we would like to see more applications coming in. I note also, I don't think we have any from the worker side as of right now. So again, I'd put that challenge out to everybody on the worker side. Maybe people could think of why it is they're not applying to receive their certificate. So I need to know of any barriers that you see to this application process. If you can think of those, that would be really helpful. The other thing I'd try to do today by way of a pitch is just run through a few of the things that the Law Society has told me that they're planning to do to promote the specialty in the future. And I'll just run through this in the order that they provided them to me. First of all, they're planning to provide more information on specialists in the directory of specialists and on the Law Society's website, and that's to better promote awareness to the consumer. The consumer's the public, and again, from the worker side, I'd like people to think that you're probably on the front lines in dealing with the public, much more so than the employer side is. The consuming public being the injured worker, and again, I think it's very, very important for the public to be aware that there is this specialty out there, and that you are actively representing people under the heading of this specialty. The Law Society is also going to be distributing the directory to all public and reference libraries and community service organizations. They're going to be redesigning their website to make it more accessible and user-friendly, and they've also put together a great little pamphlet that you'll find enclosed in the materials that I understand is going to be distributed to the public. and also to anybody obtaining the materials. As I said, there's a great resource package in the materials, and I think that would be a good addition to anybody's library on this subject, so it's even worth picking up the materials, even if you have no intention of applying for specialist certification. The other thing that I find is interesting, how many people have seen this little booklet that's come around? Implementing the Law Society's competence mandate? Okay, a few people, and that's good because it's supposed to be in by June 15th, and time's drawing near. Anyway, I happened to find this thing on my desk the other day and took a spin through it to see what was going on, and it became clear to me that the competency issue is squarely in the gun sights at the Law Society again, and I would assume that's because of the sort of ongoing complaints that the Law Society is receiving about the lack of competence in the profession. And I sat back and looked at the different models. You'll see them at page 17 of this document, and they talk about 4 models for competence models. The first model is formulation of a continuum of professional development. And as I understand that one, what they're looking at doing is looking at over the stages of a legal career, what sort of qualification, what sort of expertise should you have acquired. Model 2, random focused practice review. This one struck me as a little bit interesting because that one seems to suggest that somebody's going to come into your office and review what exactly it is that you're doing, and I guess make comments on whether they think you're competent at it or not. Model 3 talks about limited licensing, and as I understand that one, there's some notion that we can't all be experts in all areas now because there are just too many areas and too much information out there. And so what they're talking about doing is having limited legal licensing and a limited scope of your practice license right from the start, and even maybe focusing the law schools into streams early on for education purposes. And then finally, Model 4 is broadly based specialist certification. And as I understand this one, it's to offer to the general practitioners the ability to become specialized in different little areas, and through education on their own, not necessarily in any sort of a public forum, they would just be able to apply for and receive different specialist certifications. And that struck me as being somewhat akin to what we're trying to do here in this area. So to me, the fact that the future is becoming clear, that there is this increased push by the Law Society to try to ensure some competency in the profession, that speaks in favor of the specialist certification program. I think it's pretty well prima facie evidence of competence in the profession if you've obtained this designation or certification. And so again, I just leave that with you. Again, I issue my challenge. I'd love to see anything that anyone has to say about barriers or problems with the process, and we'll do our best to address those. I'd also like to take this opportunity to thank each member of the committee. They've been absolutely fantastic over the course of this whole process since 1993 in putting together the materials. As I say, they've devoted a ton of their time to it. And again, just a public thank you to all of them for this time. Thanks.
So grab a coffee and make your way to your small groups.